Good afternoon, and thank you for joining us for today's CCI Golden Horseshoe Chapter Condo Talk webinar. My name is Maria Durden. I'm a partner at Simpson Weigel Law and the chair of the Condo Practice Group. I'm also currently the president of the CCI Golden Horseshoe Chapter. Condo Talk was created to provide free, short, informative, and practical solution-based webinars to condo owners, directors, managers, and anyone servicing the condominium industry. Today's Condo Talk is the expansion of the Condo Authority Tribunals, a Condominium Authority Tribunal Powers, Part 2. We're going to focus on reasonableness. What steps should you take before you go to the CAT? Record keeping and workflow. What's the importance of organization? Multiple parties in the CAT. Can anyone go to the CAT? Owners, directors, corporations, tenants? Early resolution, when and how, and also cost recovery and indemnification. Is this available at the CAT? I'm pleased to be one of the sponsors of today's Condo Talk, as well as thank you to Elia Associates, Victor E, as well as for sponsoring this webinar. So you know, the Golden Horseshoe Chapter is able to provide these free educational webinars at no cost to you through sponsors. So thank you very much. We have an excellent lineup of speakers. Patrick Greco is a partner at Shibley Wright LLP, Barristers and Solicitors. Chris Jaglowitz is the principal of Common Ground Condo Law, as well as Victor E, an associate lawyer at Elia Associates. Welcome and welcome back to everyone. Let's start with reasonableness. Obviously, no two disputes are exactly the same. And the fact that there's going to be more disputes now at the CAT, how is this any different now for condos proceeding to the CAT? What kind of suggestions do you have?
I can jump in there. It's interesting because there's a whole new mandate of, with the CAT being somewhat summary in nature in terms of access, in terms of cost. It's designed to be streamlined and it's designed to be topic specific, and that's good. I think we were all angling for a specific venue to bring these many disputes to, but it's, I don't think we should forget the old law. There's lots of court case law and general principles that bind these disputes. A biggie, and right up until the cases this year, is you got to act I'm speaking to condos here, you've got to act reasonably towards your unit owners and residents and others. And that's not going to change. If anything, I think that's baked into this system. It's baked into the three-tier system of a negotiation and mediation and arbitration. And even before that, because we're going to get into procedure later, it makes it all the more important to be reasonable in advance. And it's not just a strategy. A lot of this can be framed as it's reasonable because you'll save money and blah, blah, blah. It's important to be reasonable because that's what's right. A board has to be reasonable, and decisions that are made have to be in the best interest of a condo with regard to morale, with regard to dollars and cents, with regard to resale value. All of that stuff is kind of what the Condo Act is driving at. It's really easy to see, we've all seen it, boards get dug in the trenches. I'm not meeting with that person. That person is blatantly wrong. See them in court. Well, you're going to have a chat with them at the negotiation phase in about a week. So why not invite them in and save all the hassle? You don't have to give them anything, even if you don't want to. But usually when human beings see eye to eye across a table or across a Zoom, it's harder to be unreasonable. You just kind of see the other person as a human being, and it tends to drive resolution. And then that doesn't mean that you're not setting up the case. We're going to talk a little bit about that shortly, and you're not getting your case ready in case reasonableness doesn't prevail. But first of all, you'll just winnow a lot of the cases out right away. And even if you don't, you can show the eventual, if it gets to adjudication, that you did everything you could to not be there. And maybe that drives costs. So many reasons to be reasonable, more so now than ever.
Mm-hmm.
Let me add a point to that. Patrick makes excellent points. A further thing to think about is, compared to when we would litigate these cases in court, it might be that the judge you draw to hear, or the arbitrator to hear your particular case, maybe they're not condo experts. They could come from different disciplines. Maybe they don't hear a lot of condo cases. At the Condo Authority Tribunal, you're going to be having decision makers that hear condo cases all day, every day. And so what we might have been able to persuade a court in the past as being reasonable might be a great deal more difficult now in convincing the CAT to say, well, you know what, this is the 50th parking case I've heard this week. And I mean, I've got an opinion as to what's reasonable, and I can assess what you, Condo Corporation, have done in this case compared to the last 49 cases that I've heard on this topic in the last little while. So, I mean, when Patrick says reasonable, I mean, that is not just objectively reasonable or what seems reasonable, it's like what really is reasonable in terms of industry practice and in terms of what those Condo Authority Tribunal members have been seeing in other cases. So that's another thing to think about here.
Absolutely, Chris. Very good points. So I hear from Patrick and Chris, the reasonableness of our actions is very important. We'll take it further. I think we also have to look at the reasonableness of our rules and our bylaws, which the provisions of can be challenged now in the CAT. Could anyone kind of speak to that? As we know, rules and bylaws have to be reasonable to be enforceable, but what should boards be doing now, perhaps in reviewing the corporate documents to ensure that we can actually enforce them? And do they need that rule or this rule? Because if the rule's enforced, then, you know, pursuant to the Condo Act, you are required to make sure compliance occurs.
Yeah, I think we touched upon this in the first part of this session a few weeks ago, and it was essentially a cost-benefit analysis. The board really has to consider with the manager whether to enforce this rule, it's worth it, because as I'm sure we're going to get into a little deeper later, costs aren't recoverable. So even if for example, the dog pooper is on camera, you got a DNA test that says the dog is that unit, is it still worth it, right? If you're going to charge him back for $40 to clean up the dog poop, and then he takes you to the tribunal for, let's say, thousands of dollars, you have to add your own legal fees on top of that. And by and large, right now, from what we've seen, the CAT does not award legal fees, even if you're successful. So until a case comes out where the CAT does say, hey, the condo can enforce and get its legal costs, it really becomes a cost-benefit analysis. Do you want to enforce this rule? And as Maria mentioned, if you have the rule on the books, you have to enforce it technically. So it really becomes, is it worth it?
Yeah, is it worth it? And I think everyone has to keep in mind you live in a community, a condo community. So what do you actually need to control and what is okay to kind of let go? Victor, I love your examples. You always seem to fixate on one specific topic though. I won't go into it. Keeping it clean, I'm keeping it clean. Excellent, thank you for that. Record keeping and workflow. There is a lot of documentation out there in all different formats. What are your opinions on how to manage it all and organize it? Best prepare yourself if you do go to CAT.
I'll jump in on that, Maria, thanks. One thing to remember is that nowadays we've got an online tribunal that takes its evidence digitally. And of course, the more documentation you're able to put forward there to establish your position, you increase the odds of having everything on the table and to settling the case. Excuse me. And of course, I mean, so whereas it used to be before, like we'd be filing all this stuff with affidavits or just, sort of loose documents, and the lawyers would put all that stuff together. And because so much of this is email nowadays, it's really important for managers as part of their daily work and condo boards to be categorizing and filing these emails in a way that makes sense. Like a lot of people use email, for instance, they just use Outlook as their filing cabinet, and without it being sorted or anything like that. And when managers or boards, send an enforcement matter to their lawyers, it's usually, oh, here, I'm going to send you 5 emails, and each of them is going to have all these photos and attachments and all this stuff, or scans of printed photos and things like that. So they're large in file size, they're unorganized, they're all titled the same, and email is just hard to work with when it gets forwarded to you, whether as attachments or as anything else. So, I mean, we've got to develop best practices in terms of like having a catalog or an archive of email. It's all in one place in a single PDF that can have 500 emails that you can sort by who sent it and when, and are there attachments, and that has the attachments integrated into those emails. Like that's just one trick that we all have to use in order to make this more efficient to deal with. Like sending your lawyer or trying to upload to the CAT 10 different relevant emails. If you're doing that with 10 different files, first of all, it's a mess to administer. Second, it's hard to sort out. And third, it's hard when you're, working within the tribunal process to refer to, oh, look at this email. And especially where, for instance, you've got, I think, some people, we're all guilty of this from time to time, where we don't continue the email threads, where, where someone's responding to an earlier email or starting a new thread. And so you lose the continuity. Whereas if you use the same email thread from beginning to end, you've got a single message potentially that has almost everything in it. So at least you can follow along. You start reading from the bottom up to the top. And so, I mean, in terms of the filing and even how you use email and who are you copying and what's attached to it, and have you got all this garbage at the bottom of your email signature that takes 3 pages, and it creates a lot of scrolling, a lot of flipping, a lot of jumping around. And you just have to remember, I mean, using email is not that much different than in the old days where we would send someone a letter. There is one page, there it is. It's kind of clean, it's easy to work with. But
Chris, I never practiced at that time. That must be you.
Yeah, I'm going to date myself here and say, yeah, the internet was just sort of coming in at the time I sort of joined our profession here and got into it. But we all have to work hard at making that email and the documents manageable. And when I mentioned photos there, if they're going to be in color, first of all, try not to have them 5 megabyte, file sizes, have them manageable. Don't print them in black and white and scan them and email them to me because I can't see them and they're of no value. The date stamp, I think, on photos is a useful thing too. And to have them, and again, those can be placed into an archive or like turned to a PDF so we're not flipping through image files. Like just so many things. Like I know we all take it for granted. So we're just working with digital files and documents, and just how can we pack those up in a way that is easy to use and all the way through the case. And actually for managers to say, oh, I don't, I've lost the email chain here, or I've forgotten what we've done, or if your lawyer or the CAT or your board asks you, well, what's the chronology of the events here? Chronologies are really, really super helpful. And if you can't piece all of that stuff together, I mean, you've got a lot more work on your hands in terms of just framing the case and say what happened here. Because when any of us go to the CAT, or we have to be able to say who, what, where, when, why, and how, and to tell a story. Litigators will tell you that the more convincing and clear and comprehensive a story you can tell, the more likely the more persuasive your case is. I'd love to hear what Victor and Patrick would weigh in on that with some of their pet peeves with the documents and the evidence we get and how we have to deal with it.
Yeah.
I've got almost like sorry, go ahead, Maria.
Oh, I was just going to say, so practically speaking, though, who does it? So emails, for example, who should be responsible for kind of keeping track of all those emails? I've worked with boards where, some boards have an individual who is really good at organizing those emails and keeping the documentation in order and filing. But do you have any tips on who actually does all this? The great ideas, but how do we play them out?
I'll take a stab at that. I mean, ideally that is it's sort of happening on an ongoing basis where, like, even just like with Outlook, for people that use Outlook, I mean, having a folder in your Outlook where all the stuff gets saved, and then if you've got Adobe DC, you can just right click on that folder, turn the entire folder content into a single PDF archive. There it is, problem solved. And just learning those tools and what works for you, and making sure that you've got the right kinds of subscriptions and having the software tools to do that. Like if you're using web-based Hotmail or Gmail or something like that, all of us do, and whether for personal, professional, or whatever use, I mean, just having that set up and then so that when whoever you send it to, whether it's to your lawyer, to your manager, to whoever, that at least it is organized. But finding the right person to be able to do that, and you want to do it for the lowest cost. Victor's saying quite rightly that cost recovery is a major issue. So who is the right person for the lowest cost to do that? And ideally, the managers and boards are, if you're working with lawyers, spoon feed your lawyers. The better you can pack it up and package it and make it concise and tight and easy to deal with, you're going to save money, which you may not be able to recover anyway. So it's worth doing.
Victor?
Chris, you're talking about some of like the really advanced, great stuff that's out there to help these cases along. We sometimes find that, I mean, we're even operating at not our office, but in the condo context, a lower threshold of, you know, who's maintaining the email account, who owns the information assets. I know the act says who does, but you know, how is it a whole email history passed on upon the transfer of management? All of that stuff, it almost feels like it was either intentionally or unintentionally planned that in the lifetime of the cat, the embryonic little thing first was records, because it sort of told the whole industry, look, everything is based on records. And we're going to give you a head start of about a year to tell you how wrong you all were on records, so that by the time we bring the other stuff in, you'll have a fighting chance on all those other topics. And it's neat to see how it has given guidance. You know, if you think back to the case law on records, it was mostly a bunch of scattered small claims court cases. I remember the one that called fishing expedition or whatever. That's all I remember. Now in the span of a year, we got like 40, 50, 100 cases. We know so much more about records and what's expected of us in the industry. And you use that to build upon the stuff that you're talking about, Chris, which is to then put in the really cool stuff to make the cases flow. Slowly optimistic.
Yeah, and part of it does require, you know, advancing. Just we have to be more technologically savvy. I mean, when owners are saying, I want the emails that you're referring to in your minutes, or I want these various documents. I mean, they've got to be produced. They've got to be stored and kept. And as you say, Patrick, quite correctly, I mean, what if managers change? What if the board changes? How is this going to happen? I mean, you've got new managers and boards coming in saying this rule enforcement thing has gone on for 3 years, but we've got no records beyond 6 months ago when management changed over, or we got new members on the board.
Yeah, absolutely. Let's go in a different direction now. So how about who can actually apply to the CAT? Does everyone have the authority to start a proceeding? Condo owner, tenant, someone across the street? Who actually has the access right to a CAT? Victor?
Sure. So right now, as of October 1st, 2020, basically any unit owner can actually apply the CAT to enforce a declaration, bylaw, or a rule, or even the act against another unit owner, or a tenant actually. So if, for example, you are a unit owner living in a condo, and to stay away from my often cited examples, let's say there's a pickup truck parked in the spot next to you that keeps, you know, encroaching on your boundaries of your parking unit. So it's a giant pickup truck and you can't get in. You can actually now take that unit owner next to you to the CAT for breaching essentially what I'm assuming is a rule or an act or a declaration provision that says that you cannot encroach on someone else's property, or your vehicle must fit within your space, basically. And in that case, if you're a unit owner, you apply to the CAT, so you send your application into the CAT, but you also now have to give notice to the condo corporation itself. So not only do you go up against the unit owner, you also have to give the condo an opportunity to what we call intervene, to have a party status as a party in this CAT application, because the theory is the condo itself has an interest in upholding that rule that says, you know, unit owners can't encroach on other unit owners, for example. So that kind of interest is what gives that party status to the condo corporation, and it's actually a requirement actually now in the rules of the CAT that you as a unit owner, if you apply to the CAT against another unit owner, you still have to give notice to the condo corp. Conversely, if a condo corp is applying against a unit owner, so for example, they get a complaint from somebody saying this guy is parking in my spot or this guy's car is in my spot, you basically as a condo corporation enforce against that unit owner. And if, for example, the unit owner goes, well, that's not me, that's my tenant, right? That's my tenant's pickup truck. Then technically speaking, the condo will also then have to issue a notice of case. So a notice that this case is going on to the tenant as well. So it will most likely in these tenanted unit situations become a three-party kind of application. It'll be condo versus unit owner and tenant. And each person will be their own individual party in the CAT process. So it's going to get a little more thorny. It's going to get a little more, we'll call multi-party, because of the different interests that are at play here, right? The unit owner probably, if let's just say a downtown Toronto condo where the unit owner lives off-site, it's an investment property for him. He's really only worried about, you know, making sure he doesn't get dinged for costs. The tenant wants to park his pickup truck, obviously, and the condo wants to enforce. And you're going to get into possibly, we haven't seen it yet, but possibly an even more convoluted situation where the unit owner brings an application against the next door parking unit, which is owned and tenanted. So therefore it'll be the owner versus the next door owner versus the next door tenant. And then the condo gets looped in, being the fourth party here, and it'll be a four-party dispute. So you're going to get some various permutations of the multi-party kind of system here. And the CAT did build its system out for that, and it is anticipating that it's going to go that way. So it'll be interesting to see when that happens and how many people are going to be inside one single CAT case at one time.
Wow.
That you know what, one thing that occurs to me in that case is how many times, especially in the context of noise and nuisance, we've got owners who are making complaints, going to the board and say, board, you got to do something with this. And the board says, well, you know what, you owners making complaints haven't been that forthcoming with the information in terms of the who, what, where, when, why, and how, and having those detailed logs and the evidence we need to do this. Condo boards will frequently say, we haven't got the evidence here to make this kind of case, but if it's going to get you off our back, that we'll start this kind of thing, but we're going to bring you in as a party because you've been making the complaints, you've got the evidence we need to make this case go somewhere. And you know what, we're doing this because you basically have been after us to do this. We have a duty to to enforce our documents, and it's either we face lawsuits from or other claims from you making complaints that we're going to go and do this process, and now we expect you to be involved with it. So like that's a further interesting twist on this. And one thing that we were talking about a little bit before we started the session is and this I don't know quite what to make of yet, is in a CAT case I began, I named a corporate unit owner, a commercial unit owned by a business corporation. I named that unit owner as the respondent. And then when the principal, the president of that company joined the case, all of a sudden the case was now condo corporation versus that person. And I'm thinking, if this case is going to go all the way and I'm going to need a compliance order, I need a compliance order against the unit owner, not against the, Mr. Smith, who's the president or whatever of the business corporation unit owner there. So that was one thing I think CAT's going to need to work itself out, because I don't want to have to be arguing at a later time to say, hey, I started this case. I named who my respondent is. Why was it allowed for that case to change in that way? I want my order against the unit owner in that particular case. I'll be interested to see how that kind of thing works out as we go forward with these cases.
Absolutely, that's a really interesting distinction there, which hopefully it's good that you appreciate it at this point and not the point where you're trying to enforce an order and hoping to lien a unit for it, right? But you made a comment, Chris, and you said that you want to get the individual involved at the forefront and document any breaches of the act or rules or declaration or bylaws. I think we've all had that case where the board comes to us and says, okay, send a compliance letter, and we'll say, okay, send me what you've sent to the owner to date. And it always comes back, well, the owner doesn't want to be involved. The complainant, they don't want to really get involved and get their hands dirty. And my response is usually, well, I can't do anything about that. That's certainly a big issue, is make sure whoever's complaining is ready to commit to that complaint and be involved.
Yeah, I think that's important. It goes to Patrick's point about reasonableness, to say, you know what, if the board's sitting here saying, well, are we going to start a proceeding in the CAT over this case? Is it reasonable for us to do that? First of all, have we validated the complaints? If we haven't, then we had better have very convincing evidence from the whoever's making complaints or whoever has firsthand knowledge of this. Because if we haven't got any ammunition, or if we don't have any reasonable basis to believe there's a violation here that's actionable, we're not going to take any action. But in many of these cases, I think we've all seen them, where you've got owners, they're saying, no, this is all your thing. You prove it, you document it. I'm just going to keep making complaints. And if you don't do something about it, I'll go to Superior Court to make an oppression case, or I'll make my own case against the condo corporation, in which case, the condo corporation is in a sticky bind. And we've seen cases like that, where unit owners making complaints will not pursue the offender. They expect the condo corporation to do it, but they won't necessarily cooperate with them.
And keep in mind, the CAT does in no way all the new procedural permutations in no way take away from the condo's duties under the Act. And even that evidence collecting exercise has always been a little weird. In the shiny silver tower with 24-hour concierge, easier to know what to do. What do you do in a townhouse with no on-site staff and ongoing smoke complaints? We've had boards who have said, look, here this week, it's the president's phone number. Next week, it's the vice president's phone number. You call us anytime before 11 p.m., and this is even more difficult during COVID, and we will come over and we'll be the corroborator. And we've spoken to boards who have said, I don't want, that's not my job. I'm not security. I don't want to do that. And I say, I respect that. You know, I'll talk to you when it's time to go to court or CAT, because you just don't want to collect the evidence needed to solve the problem. And then they go, okay, I guess I can be reached till 10 p.m. Yeah, but you got to get creative sometimes in collecting the evidence because it's not a perfect system with perfect personnel in place.
Yeah, that's absolutely true. We have two questions that came in through our chat. So I'm going to read the first and then the second. The first is, when deciding whether or not to enforce a rule, isn't it possible that an owner can take the board to the CAT for failing to enforce the Act, the declaration, bylaws, or rules?
Yeah, you're going to get that a lot, I think, in the coming few months, if not years. I think that's going to be a huge issue because, again, the board and the manager have to make a cost-benefit analysis. And if they think it's not worth it, they're not going to enforce. Then the unit owners are going to say, well, I'm going to go take you, condo, to the CATNAB for failure to enforce. It used to be before the expansion that happened in October, it used to be that if you wanted the condo to enforce something, you would have to go to Superior Court to force the condo to enforce. And so that was always a high bar that very, very rarely did anybody actually do it. But now with an online tribunal and a pretty easy to access system with low fees, you're going to get a flood of those kinds of cases where the people who are, for example, noise especially, it's not within the jurisdiction of the CAT yet, but it might be soon. But let's just say my favorite example, dog poop. If somebody keeps stepping in the dog poop every single morning on their jog outside, they're going to start complaining very loudly to the board, and the board is going to be like, well, it's not worth it. We don't want to risk the legal fees and the exposure in the CAT. That jogger is going to take that condo to the CAT pretty soon because he's going to get fed up. And so you're going to see a flood of those kind of cases, I think.
You know, in that particular case, that's where the board, if they are named a respondent in a case like that, and it's alleged that they have failed to enforce the documents, that's where the board's going to say, you know what, we've asked you 3 times, Mr. or Mrs. Complaining unit owner, for information to corroborate your complaints. We've done what we could to try to verify them, but we couldn't. We asked you to assist us, and if in fact the owners complaining have not sort of documented that or cooperated in that process, you know, their case isn't going to go very far, but the condo corporation is going to have to be able to establish that they've taken reasonable steps to investigate the complaint. How do you do that? Obviously, the email exchange is going to be important, you know, to have those little bullet points or chronology or notes to the file to say, yeah, we got these complaints. We, you know, if we have security, we sent them up, they heard or didn't hear anything, or we asked the owner for additional information and we got some or we got none or whatever. So like, this is where we're seeing where this can go here, and it's going to probably be a fair bit more work for the managers and boards going forward.
Thank you, Chris. And Victor. Chris, I like it because you merged reasonableness, really concise, clean keeping of your documents, and how many parties could actually be involved all in one comment. So that's really much appreciated. Our next question is, and Chris, this one will be for you. If a condo unit title is a numbered company, so the unit is owned by a company, owned by a person who is living in the unit, what different processes are needed for sending communications? So let's say notices or compliance letters.
Right, and of course, this is where we'll make the usual disclaimer that none of this that you're hearing today is legal advice. But of course, I mean, good managers know, and it's part of the reasonableness thing that Patrick talked about, is that we communicate with the occupants and with the owners, because remember, we're ultimately looking to the owner to potentially pay some or all of the cost of this proceeding. It's important also to communicate with the occupant to say, well, there's a problem here. This is what it is. I mean, in that case, I mean, basically it's 2 letters. Even if they're going to the unit, if the numbered company that owns the unit, if their address for service is the unit, same as the occupant, it's principal. Yeah, that's where it would go. It's 2 letters. And actually, what my thought is, and if Victor and Patrick may agree, if you're going to start a proceeding there, you've got 2 respondents. You've got the occupant and you've got the unit owner. It makes sense to name them both. Like, I can't think in any of those cases where we've got a tenant involved, why would you not have the unit owner involved?
Yep.
Because it's the owner, after all, who has to secure the compliance. If, mind you, if the owner basically and the occupant are essentially the same person, just separated by a business corporation, we still have to go through those steps of naming both parties, and that's what we would do ordinarily.
Yeah, and you can't assume that because you send the letter to the unit, the owner actually receives it. So our general practice would be to send the letter to as many locations as you can to get compliance, hopefully sooner rather than later. So that's why it's also really important to do a title search to see who actually owns that unit, because perhaps even though owners are required to give their address for service to the corporation, not many do. And the assumption is usually, well, you are going to send it to the unit. So just don't make that assumption. Find out where else can they locate the individual who owns the unit and send out those communications to those addresses. Another question we have, really, really good question. So, if an owner requests copies of board minutes under a request for records, and when the property manager sends those minutes for the period specified, but the owner who requested the minutes knows that there were other meetings of the board during that time period, but minutes of those meetings were not provided, can the owner who made the initial request for records go to CAT to dispute this? Patrick, what do you think?
Sure, it's a great question, and it's an interesting one because it has been dealt with in a sort of interestingly conflicting way in some of the cases in the last 6 months. One of the cases that came out dealt specifically with not the existence of the minute, but the content of the minutes being quite inaccurate. And the chair in that case, in relying on the wording in the statute and the regs, which said they can make any reasonable order in the circumstances, said, I'm going to order you to correct these minutes. Another case said, well, look, no such record exists. I can't order you to produce a record that doesn't exist. If I had to square those 2 cases and tell you where I'd like to see it go, I think there could very well, first of all, yes, I think the owner could apply. And I think they very well could receive an order compelling the board or the corporation to create minutes for that meeting that were not taken. I think it's too cheeky by half for the board to say, well, the meeting we talked about that really controversial thing, no minutes, don't know what you're talking about. I think they're going to get raked over the coals. And a little asterisk on that one. A related point is the, I'm trying to remember what it's called in Harry Potter, but the cape that makes you invisible. A lot of boards want to use the contemplated litigation exemption as that cloak to not put forth records that frankly often could resolve the dispute. They go, well, this is a contentious issue, probably going to be litigated, not going to give you the records. Boards are often surprised to hear that as soon as litigation starts, be it the CAT or be it a court, all those rules fall by the wayside other than some really small ones about solicitor-client privilege, and you're going to have to give up those documents to prove or defend your case. So as long as they don't contain highly, highly confidential info, or something like unit or employment info, if it's just about a little squabble, oftentimes you should step back and take a look and just put the record forth. It applies to these minutes, it applies to a host of other things. It all feeds back into the reasonableness stuff on that we started on.
Patrick, the point about that case not too long ago where the CAT member ordered the corporation to basically create records and things like that, I think, like, where we talk about the expanding jurisdiction of the CAT, I don't think any of us saw that coming. That was a pretty drastic move from, is this a record that ought to be produced? Well, this is a record that ought to be produced, and if it doesn't exist, it ought to be created, or corrected. And we're just saying, whoa, where does this come from? And it could well be, like, I get where the member was trying to go with this, but the day may come where, where the right kind of thing happens over a large enough issue where it's possible, and like the decisions of the CAT can be, if they exceed their jurisdiction, for instance, that's a legal error, and that could be taken, of course, to court, and we could get a court to weigh in on exactly what are those boundaries and to what extent can the CAT say, well, you've got to create records, modify records, correct them, or whatever. And I mean, mind you, the takeaway is condos have to create records, be an open book, be transparent, comply with the law. But I mean, just there is a fine line in there somewhere, and there's going to be a case one day where where we do have to have some clarity and some boundaries.
Yeah, Chris, this reminds me of kind of similar to this with respect to owners' meetings and minutes. And I know that there was a couple of years ago, I was at a conference, and the question is, does every owners meeting need minutes, which then have to go on to the next meeting and approve, for example, AGM. And someone stood up and said that they spoke with a CAO. That's always my favorite. I spoke with a CAO. I always wonder what, I want to call them and I want them just to do it. And the CAO said that as long as you don't call it a meeting of owners, or even a town hall, it's more of like like you use the most informal language. So we're going to have a wine gathering in the common area to discuss stuff. Like, don't have an agenda, don't call it a meeting, maybe even say the time is fluid. Really don't commit to a lot of things, then theoretically the position is you don't need minutes of an owners meeting. So all is to say is that if it's a duly constituted board meeting, yes, you need minutes. You have to document that. I don't think, like Patrick said, you get the invisibility cloak and pretend it never happened because you don't like the outcome of it. But same with owners meetings, you need those minutes. They become a record of the corporation. If you don't want that, then you have to make sure that when you hold that meeting is not designed as a meeting of owners, that is a formal meeting that needs quorum, or even if there's no quorum. Even if there's no quorum, you may need those minutes. You may not be able to make decisions, but it's a meeting of owners. So just be very cognizant of the wording you use in any letters you send out versus notices to owners about this gathering.
You know, Maria, you make a good distinction there, and that is the kind of case where the CAT could take it way too far. If we say this is not a business meeting, there is no voting. It's a free country. We can gather, we can talk, we can take straw polls, we can do stuff like that. But if we're making binding decisions of the board or the owners, or transacting business, then yeah, I agree with you there. That's where you've got to have minutes. But you know what? Clearly, I mean, the argument could be made there. And you know what? How often do condo boards say, "Let's gather and talk. We're not making decisions today. Or we just want to kick this around, or we want the lawyer to come in and talk to us, or our engineers, or our auditors, or whoever, and just talk to us and answer our questions." That is not a business meeting. That is a conversation. We just happen to be gathering. It is a meeting of a way, but it's not business.
Mm-hmm. And just so we are clear to everyone listening today, we are not proposing you gather of more than 5 people at this time. So just, of course, that's minor caveat to that. A couple more questions came in through the chat. So what is the cost to file a complaint? Do we know?
I understand it's $25 for whether it's a corporation or an owner to file an application in the CAT.
Okay, and we'll talk about costs and indemnification later, but just to simple yes or no, does the CAT award costs?
Not for normal cases, I'll say that. To be honest, 98% of the cases probably I'd say do not get awarded costs. There are very, very, very few exceptions to that rule. Hopefully, and we'll get into this later, the new expansion of the CAT will allow for maybe some more what we call exceptional reasons to allow for cost recovery.
Okay, now what about if a complainant starts a CAT proceeding, gets through it halfway, and then says, I'm kind of done, I'm going to sell my unit and move, or they just stop? Is there any recourse the defendant has with respect to costs? I mean, I've now hired possibly legal counsel, I've filed documents, I had to take time off work. Is there anything to that? No.
Most of the time, the board is just happy to have the dispute resolved and gone away, basically. But no, unless you put a notation in a stash certificate, which itself is risky, I I think, to be honest, most boards are just very happy to have this person out of their community, out of the system, and move on.
I'll tell you, in about a week or two, we've got a case that has lingered in stage 1 for going on a month, and it's been lingering there because the applicant owner posts a new screed every 1 or 2 days, implying that one of our associates isn't who they are, that we don't represent the condo that we say we represent, that we have hacked the CAT system to change the title of proceedings, which was just a little typo on the CAT's end. We've hacked it in order to interfere with the process. And interestingly, CAT of its own motion, I don't know, Chris, Victor, if you've seen these, they've of their own motion sought submissions from the parties as to throwing the case out. And our client has asked for costs. We will see if even something as grave as that triggers more than the couple $100 that Victor's shaking his head on. I tend to agree.
You know what, though, what you might get in that case, Patrick, if you've got someone who's basically just throwing stuff against the wall and trying to obstruct the process, the odds are you may have a potential argument there, or any party would in that kind of case, to say, if the other party is not sort of collaborating with us in this case in good faith, that maybe they're a vexatious litigant, not to be bringing further proceedings there.
Yeah.
I wouldn't be holding my breath, though, because I know I've tried to get costs on a what we call the scandalous allegations case law. So if a unit owner in regular court makes what we call scandalous allegations of, let's say, fraud, or I guess in Patrick's case, hacking, or some sort of criminal activity on behalf of the other side, in regular court, the judge will award an elevated level of costs for the person that was accused of that wrongly. I tried that argument and it did not work. So I'm not holding my breath for your costs there, Patrick.
No, I'm not either, trust me.
There's always the next case, Victor. Maybe if we do part 3, you'll have different opinion on that. We'll see. So on the kind of on the same mind frame as early resolution, is this possible when a CAT proceeding is commenced? Can you kind of discuss things outside of the CAT? Is this possible? Chris, I know you had a proceeding started when we did part 1 of this over a month ago, which seems crazy to me, over the parking issue, commercial parking issue. Do you have any insights or takeaways on that matter?
Yeah, one thing, and I think I reported on this the last time, that basically after the unit owner got wind of the case, after it was basically given to them, luckily I had the owner's email address, so they received notice of the case, and it opened a dialogue, and we're working on it, and I'm, as the intermediary here, getting information from the board, and I'm trying to help them, prepare some terms for a potential settlement here. So it got a discussion going, which is great, because I mean, no one wants to have to go through the additional processes. And of course, following the initial negotiation process, then comes the facilitated, negotiation, mediation process, and then adjudication. We'd love to wrap this up in the first stage of the proceeding. So one thing I found with this process that I think, this is a great strength of the CAT, is that if you've got a party who's interested in being responsive, you can start that dialogue, you can get things done. And you'd ask Maria, is it possible to take that conversation offline? And the answer I'd say is absolutely yes. Like if the board says, can we chat with this guy because we've got a problem with something else or something, and definitely that's possible. And in fact, it's becoming pretty routine in CAT's cases about records. They say, and as usual, this case deals with a whole lot more than just records. Like they might as well just put that into every decision they write.
Form.
Yeah, it's part of the pre-fill. And so if it's possible to get to that underlying issue, and whether it's in records or people parking, storage, or pets, to get to the bottom of it and to have some conversation. I mean, sometimes just the weight of bringing this quasi-judicial proceeding against someone, they'll recognize that this is serious stuff, and they will open that dialogue. And of course, that means, this is back to Patrick's very important point about being reasonable, is are you being reasonable with how the process is going? Like your board and your owner just can't say, nope, it's my way or the highway, that's it, or I'm not interested in talking. You've got to talk. You've got to at least put some effort into trying to resolve the thing.
Now, what's your recommendation on, let's say the opposing side didn't come to you and say, let's talk. Do you think you ever make the recommendation of, let's see the doors open and see if they're open to that idea? Do you think that's a good strategy at times?
I think that's baked into the whole process, which is fantastic, and that's a great thing, because when you look at us going to court, or like take the small claims court, for instance, you've got your settlement conference right there at the, after defenses get filed, the deputy judge listens to both sides and goes, well, I see you guys aren't going to be able to settle this, and so good luck with trial. I mean, whereas the CAT thing, like if your initial negotiation doesn't work, you're into the facilitated negotiation, and even through into Victor can speak to this point, we get into the adjudication part, there still is opportunity to resolve the thing at a lot of stages.
So communication. We have a couple more questions that came in. Thank you so much for sending them. This one, if a manager receives a complaint from an owner and brings it to the board, but because it's a controversial issue, the manager suggests there be no minutes of the discussion. So it sounds like there is a meeting of the board. We're going to assume it's duly constituted, but no minutes taken. If manager has email of complaint, who is responsible for non-documentation? So who does the responsibility fall to with respect to actually having minutes of a duly constituted board meeting? What do you think, Patrick?
That's a juicy one. And first, I'm going to turn the assumption on its head, which is because it's a controversial issue, there's a recommendation to not take minutes. I say because it's a controversial issue, please take minutes. You're not talking about the wine and cheese for the Christmas party. You're talking about a controversial board business issue. So I think there should be minutes. And I think the question asker here is sort of recognizing that. Ultimately, if we're going to first principles, the responsibility lies with the secretary of the corporation to ensure that minutes are taken. However, that is usually contractually handed over to the manager, or by custom that there will be minutes arranged and taken for meetings. So unless the board of their own volition said, we are not taking minutes, manager, and we recognize your advice to take them, but we're not, in which case it would be the corporation or the board directly. In this case here, it would probably be the manager for kind of giving some wrong advice that you not take minutes on a meeting. Ultimately, it's the corporation who's going to be in the crosshairs of the CAT complaint, but then they may turn the gun a little bit on their contractual service provider and say, why'd you tell us to do that? Or not to do it, as the case were. So.
Yeah, keeping in mind that the CMRAO now requires the condominium manager who you're working with to comply with the Condominium Act, the declaration, bylaws, and rules. So turning a blind eye was never an option, but now we legally know it's not an option. Sorry, Vic, you had a comment?
Yeah, so in that scenario, if the manager is concerned about the controversy, what you can do is have them as in-camera minutes and then claim the protection of litigation privilege or contemplate a litigation later. So Patrick's right. First principle, keep the minutes. It's good for you as a manager. It's good for the board as an entity going forward. And if you need to protect it from disclosure, there are ways you can do that if there is a live controversy. So it's not just, we have it, we have to disclose it. There's also that backstop. So I would definitely agree. Keep the minutes. Better to have minutes than not.
Yeah, and I think it's important for us to go back and say, what is the purpose of meeting minutes? And it's not to rehash the discussion, and it's not even to summarize the discussion. It's to say the board had a discussion, and if the board made a decision arising from that discussion, to say board resolved to, made, seconded, carried. That's the decision. That's it. And I mean, if people are putting a whole lot more detail in there, and I get it that some recording secretaries and some boards and some managers really like having a whole lot of detail in their minutes, you just say you're walking a fine line there, and that's probably going to come back and bite you in some way. Because what happens if you made a mistake? What happens if some fact in there turns out to be incorrect? You've got the Condo Authority Tribunal coming out telling you to correct your records and your minutes, which is absurd. So, I mean, I'd say keep those minutes brief as possible. And I mean, I think it's fair game that directors have their own, notes as their, memory aids to assist them at a later time, whether or not those are records. I mean, that's a discussion. Maybe there's been a CAT case on that, but you know what? I'd say be careful what goes into those records.
Meeting minutes. Yes, meeting minutes. That'd be a good topic, I think, to actually have to dive into a little bit further and give a little bit of recommendations of best practices, food for thought. But we have another question. You know, with the rise of Zoom meetings or any kind of electronic format, what about video or recorded Zoom meetings, for lack of another provider at this off the top of my head, for AGMs or board meetings? They're recorded. Can those be used as the minutes, or do they have to be physically recorded to be a record of the corporation?
I'll let me start that. I'd be interested to hear what Victor and Maria and Patrick have to add to this. Is when I'm chairing those virtual meetings these days, I say right at the outset, the meeting's being recorded for the express and sole and restricted purpose of assisting the minute taker and taking the minutes. And that generally in that way, or especially if I am hosting the meeting, the recording is in my custody. And if I share that with the minute taker in order for the minutes to be prepared, that's it. It's not a record of the condo corporation. And I mean, if you state what the purpose of it is, and I mean, but if you do that, if you say that that's your purpose, then the board had better not have the recording. And it better not be on corporation assets or its service providers or its managers' equipment.
Yeah, no, I agree with that. I always start my meetings the same way. I always say, look, it's being recorded for the purposes of the minutes, and that's it. There are situations where we've come across now with virtual AGMs where people do say wrong things, right? The auditor might misstate something. Somebody says something off the cuff that's not correct. And if it's a Zoom recording, you can't correct the Zoom recording. You can only correct the minutes later if it is, for example, it's just a typo or a misstatement. So I always tell people, look, the Zoom recording is being made for the minute taker. It is the internal work product or the notes of the minute taker, essentially. And it's no different from when some minute takers showed up with a laptop and a tape recorder next to the laptop. It's the same as that, basically. This is just a virtual version of that. Obviously, there's no cat case yet on it, and I'm sure there will be one day. But so far, we've got no guidance. So right now, our position is no, it's not a condo record.
Yeah, and minutes, I've been desperately Googling here to try to find out the Latin etymology of it, but it's a reduction of what happened at the meeting versus a transcript. The video is a transcript, and Victor's point's really astute, is you can't correct the transcript, nor do I think the Act and many people's bylaws refer to transcripts. So totally agree, and totally agree on the separation of that asset, though, so it doesn't kind of bleed over into to being a corporation record.
Here's a really interesting one. So this individual lives in a community that involves a common facility committee representing 17 condos. The CFC is not a condo and is not incorporated. Can the CFC, so this committee, apply to the CAT for disputes with individuals that reside within those 17 condos? Or must one of the individual condos apply to the condo? The CAT. Great
question. You know, when you think about it, I mean, if it's anything other than a condo corporation, I'd say a shared facilities committee, the CFC, whatever you want to call it, what jurisdiction? First of all, they don't legally exist other than in their boardroom. So I would argue that they wouldn't have standing to make any kind of application. I mean, in that case, you'd say, you know what, this individual here who's breaking rules is a member of your condo number 123. So you know what, you make this application, we'll back you up with whatever records that we've got. Rather than, you know, you don't necessarily need all of these parties involved. The CFC or SFC has no standing in that case. What do you guys think?
Yeah, it leads to, I agree with you, Chris. It also leads in what you just raised, leads to a bunch of different weird permutations. Let's say visitor parking shared facility is in Tower 1. Tower 1 is not enforcing that, or the shared staff is not enforcing that. All the owners in Tower 2 are complaining to Tower 2's board saying, the visitor parking is always booked up and no one's doing anything about it. Does Tower 2 bring that application against the parker? Do they bring it also against Tower 1 as their partner in shared facilities? I don't purport to have an answer today, but there's all kinds of loop-de-loops it takes you on.
Yeah.
Yeah, it's kind of the same thing with shared facilities committees. This is a large 17-member shared facility committee, but it's the same issue, right? But we go back to the intervenor multi-party status stuff of the CAT right now. So if it's a parking issue, for example, If you are a condo corp, you can technically bring it against another condo corp, but you have to give notice to the unit owner and the tenant of that parking unit that's in question. So it might, you're right, it might be a 17+2 party CAT application going on here. And that's going to be a huge headache. But my feeling is that the CAT hopefully eventually is smart enough to say, look, it's that one parking unit is inside the property of that one condo, and limit it maybe to just 2 or 3 condos max instead of having all 17 with 17. I don't even think there are 17 lawyers in Ontario that do condo law that would be non-conflicted out from this. So it's definitely something that CAT should look into, and that's a very unique situation. So hopefully the CAT will, the staff at the front end will recognize that maybe not all 17 condos have to be on this CAT file.
Yeah, I thought that was a really good one there. A little bit different, right? It's always nice to kind of tease our brains a bit more. We had one more topic to review. We do have more questions. So what do you guys want? Do you want to do the last area, or do you want to answer the questions? What do you prefer?
Maybe we'll stick with the questions. I don't know if we have, yeah.
Sure, no problem. Okay, we had an AGM. We used a company. The AGM was via Zoom. And there were also votes cast through polls and direct messages to the property manager. After the AGM, the management changed. So they switched managers. If we now get a record request to see the ballots, how do we do that? Because they are technically with the old manager. Suggestions?
So it depended on who the chair was, right? If the chair was a board member, for example, the president technically would have possession of the ballots. Now, practically speaking, they would just ask and get quorum, hey, send me the ballots, send me the proxies that were submitted to you. They really should not be in the possession of management. Management only acts as an agent for that chairperson or for the board, and get quorum is a service provider. So you can just ask get quorum for them as, you know, the board or the chairperson. So that shouldn't be an issue. I know get quorum is pretty good at record keeping, so hopefully they have it still. And again, it should be the chairperson that has possession of those ballots.
And even, you know, we get managers changing all the time. And so, I mean, the issue comes up, well, we're having, you know, the board says we're having trouble getting records from a previous management firm. Well, CMRAO obviously has, as part of the code of ethics and as part of the management contract, and there are these various things. I mean, it's not really an excuse to say, oh, the previous manager has it and they're no longer our manager. They've got an obligation to turn stuff over. The condo corporation has an obligation to have and to keep that stuff and to make sure it can get it if it's requested to produce it. So there's that part.
The interesting question there, which is more of a technological one, is there a record of those direct messages, not the polls, not the ballots, not the proxies? If someone was having trouble clicking on that link and they said, okay, just to get you to vote, please send me your vote directly in the chat bar. I don't know if that record exists. That, again, we'd have to get some confirmation on that.
You mean the chat that can go on? Is that what you're talking about?
Yeah, it says they cast votes via direct message to the PM, perhaps in the chat bar. Private message in the Zoom chat. So I don't know the answer.
Yeah. So I believe that everything that you chat, so everyone out there on a Zoom meeting or any kind of web-based meeting, in the chat that goes on, it does become a record. So it is saved.
Mm-hmm.
So they do have that. The other thing I can confirm is that, so electronic documentation is considered a record of the corporation. So whether you have a hard copy of the declaration, but also a copy of it electronically, that electronic copy has to be provided. What does not have to be provided, I would suggest, is the platform on which you've saved those documents, because that generally is a license that the manager contracts with the company to keep the documents in that kind of format, but the document itself should be transferred to the new manager. So it sounds like you should be okay with that one. We'll take one last question because we're almost done. I cannot believe that was an hour. Oh my goodness. Okay, what about in-camera motions and minutes? Are those records of the condo? Patrick, you're going yes.
Yeah.
So.
They most certainly are. And they're not, they don't wear a special silvery shiny suit or anything. They're just minutes like any other. The only time they matter is when a records request comes in the door. Otherwise, they are minutes, although any prudent condo should be, after their meeting and when their minutes are being prepared for approval at the next meeting, it's just good practice to sequester the two so that when the request comes in, you're not permitted, in fact, for the past 12 months to charge for redaction of those minutes. It's expected that you will just keep them separately, and that makes your life a lot easier as well as a condo.
Right. Yeah, that speaks to like the best practices there in terms of you prepare the minutes in a way that's easy to deal with them later, so that you're not spending a lot of time and labor later, for sure.
So just one last thing, it's just putting them in camera does not automatically encloak them. Like I guess Patrick was saying with Harry Potter, it doesn't magically cloak them with what we call privilege or a statutory exception under 55(4) of the Condo Act. It's not automatic. You can't just say it's in camera, therefore it's automatically private or automatically litigation privileged. You have to do that test. You have to assess each record individually. It's not automatic. I know lots of people think it is. If you put it in camera, you'll never have to disclose it, but it really is a case-by-case basis. So it's not that invisibility cloak from Harry Potter.
Well, we can be hopeful. Okay, it's 1 o'clock, and I'm sure people have had enough of us. But this is clearly a hot topic. We didn't even touch on our fifth issue, which was cost recovery or lack thereof, and the indemnification provisions in the declarations and the enforceability of them, and collecting cost awards. So maybe we're going to have a part 3 at some point. We'll see. But I just want to say thank you to Patrick, Chris, and Victor for sharing your best practices and practical solutions. And thank you to those who were able to join us today. Our upcoming courses and webinars, we have the Intro to Condos on December 3rd from 5 to 7 p.m. Then Lawyers, Guns, and Money. This sounds interesting. Condo Cases on January 28th from 7 to 9 p.m. And we also have the Enhanced Directors virtual course, which starts February 1st, Monday and Thursday nights from 7 to 9 p.m. And also, we would love to get your feedback from this webinar. We do take your comments to heart, and we try to tailor make our seminars to fit to today's issues. And on that point, although it hasn't been announced, I think our next Condo Talk will be something along the lines of what happens if the condos in the Golden Horseshoe chapter area turn gray, or the lockdown occurs. We've learned so much over the past few months. A lot of times we did a lot of educated guesses, best practices, but now we have a little bit of more experience. So what happens if we are locked down in this area? How is your condo going to be impacted? Hot topics that we're hoping to present it to you within the next coming weeks. Thank you again to Chris, Patrick, and Victor. It's always a pleasure to present with the three of you. And thank you to everyone for joining us. And we hope you enjoyed today's Condo Talk and hope you have a wonderful day. See you soon. Bye.